Ready, start. In the case of Radha Kanta Pal, the predecessor of the plaintiff before the High Court, had signed a bond with one Comilla Banking Corporation Limited that had since amalgamated with and was represented by the defendant bank, by virtue of his bond, in consideration of the appointment of his relation to the post of cashier and in consideration for the due discharge of his duties, the predecessor of the plaintiff stood as guarantor to the extent of rupees 10,000 for himself, his heirs, executors and assigns, the service of the relation came to be terminated, but the deposit money was allegedly to not have been returned to the plaintiff. In response, the defendant bank claimed that the relation of the predecessor of the plaintiff was the cause of shortage of the bank's cash amount of rupees 8,800, and the bank is therefore entitled to deduct money out of the security deposit. The plaintiff claimed that neither he nor his predecessor had any knowledge of the defalcation or breach of duty committed by the relation, and the bank gave to notice to them regarding the same. The High Court of Calcutta observed that in order to attract Section 139 of the Act, it is not only that an act or omission that is inconsistent with the right to the surety is done by creditor, but also that the eventual remedy of the surety against the principal debtor is impaired. As there was no such impairment of the eventual remedy of the surety against the principal debtor, the plaintiff case was said to have failed. In case of Vishwanath Agrawal, the facts were that one Joe Panja, the principal debtor, had approached the respondent State Bank of India for a cash credit facility for the purpose of running his business up to the sum of rupees 2,50,000, for which the petitioner therein stood as guarantor to pay the dues in the case of default